Hello, my name is Osha. I like talking about American presidents. Today, I'm going to be discussing the Sixth Amendment. Of course, the Sixth Amendment is part of the Bill of Rights, which our fourth president drafted for us, provided us in as part of the Constitution. So, the Bill of Rights, they're the first 10 amendments, and they protect our rights as citizens, our liberties against government overreach, and also they protect. We find that the Tenth Amendment protects the state as well in its delineation of powers between the state and the federal government. So today I'm going to talk about the Sixth Amendment. So, assuming you've been charged with a crime, the Sixth Amendment, what it does is it protects the rights of the accused. It's one of those amendments that protects the rights of the accused, and they include the Fourth Amendment, the Fifth Amendment, and as I said, the Sixth Amendment, the Seventh Amendment, which is civil, and then the Eighth Amendment. I'm just going to quickly state very concisely what these amendments are. The Fourth Amendment protects Americans against illegal search and seizure. It it requires probable cause, that the police, the government should have probable cause, and they should also have a warrant. So illegal search and seizure, same as unreasonable search and seizure. So that's the Fourth Amendment. And of course, the Fifth Amendment deals with your right not to self-incriminate. That's your right to remain silent. It includes your Miranda warnings. It includes the your right of due process, which applies to the federal government. And then the Sixth Amendment, which I'm going to discuss now, that includes, your right to know your charges, your right to counsel, your right to a fair and speedy trial, your right to a public trial, and your right to a trial by jury. So that's concisely what it is. And then there's a Seventh Amendment, which is your right to a jury trial in certain federal cases. So it's a civil in certain federal civil cases, right? In certain federal civil cases. So that's that's a civil that's with regard to civil, and it's not criminal. I've done an earlier video just talking about fruit of the poisonous tree, which is an example of the exclusionary rule and prophylactic rules. So that doesn't apply to the Seventh Amendment because the exclusionary rule applies to criminal cases. So and then there's the Eighth Amendment, which prohibits excessive bills and fines and prohibits cruel and unusual punishment. So as I said today, I'm discussing the Sixth Amendment, not so much, but what I want to do is just delve into what's called courtroom proceedings and legal proceedings once you've been charged, because the Sixth Amendment has to do with you being charged already. So you've been charged with a crime, you have a right to know your charges. You have a right to have a counsel to defend you in court. You have a right to a fair trial and a speedy trial, right? And then you have a right to a trial by jury. You have a right to a public trial. So those are your rights once you have a criminal case, against you. Once the state brings charges against you. So I'm going to talk more about courtroom proceedings and legal proceedings today. The reason I'm doing this is because I also realized I did a Fourth Amendment video just discussing fruit of the poisonous tree, and some terms I used. I realized that, well, some people might not actually understand these terms. That I graduated from law school. I'm a lawyer, so it's easy for me to understand them. But I realized that lay people might not understand what these terms are. So and it's kind of important because even though I'm a lawyer, I have a law degree, I was wrongfully charged in the state of Maryland, right? I was framed by Montgomery County police officers who assaulted me in my home without an arrest warrant, right? So this is kind of pertinent at this moment that I'm doing these videos. They had no arrest warrant. They falsely imprisoned me in my home, and then they assaulted me. This is where they shot me in the head with a taser dart, almost killing me, right? I hadn't committed any crime. They had no probable cause. They came on a hoax, right? A swatting. Someone made a false emergency crisis call. And so they came, surrounded me, and raided me and injured me, almost killing me, shot me with a taser dart in my head, right? So, and they tasered me multiple times. They released a chemical bomb into my apartment, tear gas, pepper spray, and they removed me naked, right? They dehumanized me. They were barbaric, in their actions, right? In cuffs, and dumped me in a hospital. And then eventually they had charges against me, claiming that the officer who shot me in the head, uh, that I assaulted him. So we go through discovery, we look for, because they charged me, they're false charges, and then I'm saying, no, this isn't what happened. So that's prosecutorial misconduct and police misconduct. So I get to prove these things in a court of law. So one of the things that happens is once you've been charged with a crime, the state of Maryland, where this happened, I was residing in the state of Maryland at the time, they have amongst the most corrupt criminal justice systems in the world. I would never have known, at least in America, I would never have known if I hadn't been assaulted and wrongly charged by the police, because I'm a law-abiding American citizen. I've been in America for a long time, and and I actually work. As of that day, I worked for the Department of Defense for the federal government, holding a top secret TSSCI clearance. So in order to have that clearance, it's one of the highest, about the highest national security clearance you can have. You have to have, you're clean as a whistle, right? So you're a light, law-abiding person. They know the sort of person you are, the sort of character you have, that you're a person who's stable, has integrity. So in any event, I came to see that the things I learned in law school, that's not what happens in practice in a courtroom. And I came to see that a lot of the less privileged Americans, less privileged people, their rights are routinely violated by rogue prosecutors, rogue cops, and crooked judges. So judges should be independent, but that's not the case. That's not been my experience in Maryland. So excuse me. So, uh, so for instance, in Maryland, this judge, his name is Judge James Bonifant, and he's been ordering incompetency to stand trial, right? Orders for me, right? Orders incompetency to stand trials as pretext to try and coerce me to take the plea bargain, which the state prosecutor offered me. Right away, they offered me a plea bargain to drop the case. And I said, no, the objective of them offering me that plea bargain is to prevent me from being able to sue or bring charges against and to prevent prosecution against the corrupt cops, by trying to say, well, I'm responsible for my victimization and my abuse from a swatting, right? Which I had no idea whatsoever, right? So this is so they offered me a plea bargain, and when I refused it, the judge tried to coerce me by doing an incompetency to stand trial order, right? Forcing me to go into a psychiatric hospital, right? To go and take treatment. The treatment there, so in my case, I don't have a mental illness, so the judge can't force me to take treatment for an illness I don't have. So there are these loopholes, there are these basically it's fraud on the court that was committed. But in any event, when I get to the hospital, instead of giving me any sort of treatment, because fortunately the doctors, my family, my aunt's a psychiatrist in Maryland, and my family gets involved. My mom's all the way in Nigeria, so my mom gets involved and says, no, this man is middle-aged. He has no history of mental illness. We don't see anything wrong with him. You can't just send him to uh, a hospital, a psychiatric hospital, to take treatment because you charged him with a crime that has nothing to do with the charges. So, in any event, fortunately, the doctors, because the doctors and the judge, wrongfully committed me to go to, right, in the state, they themselves also determined that I had no mental illness. So they refused they couldn't diagnose me with any mental illness. So they clearly stated that I do not have a mental illness. And so they couldn't diagnose me with anything, and they couldn't recommend any medication. So But what I ended up doing in these hospitals, this judge sends me to wrongfully. So it's a wrongful involuntary commitment, was to take a competency to stand trial evaluation. So what they're basically doing is to teach you about the charges, to teach you about courtroom procedures, and to also teach you about, to teach you about how to conduct yourself in court and how to work with your attorney. So that's what competency to stand trial entails. It entails three things in the state of Maryland. One, you understand your charges. Two, you understand court proceedings. And three, you're able to work with your attorney calmly. So those are the three things. Now, typically, a judge shouldn't order that. The law in Maryland actually says that there are only two reasons why he should order a competency to stand trial and why you can fail it is, one of two things. One, that the defendant is mentally retarded, suffers from mental retardation, right? That's not my situation. Uh, the doctors, the hospitals they took me to, they tried to do IQ tests on me. I said no, but they determined that I'm a highly intelligent person. That was their determination. I don't know if I didn't need any of them to be able to show that, right? To be able to tell me that, because one, my parents who sent me to the best schools from Nigeria. I'm a graduate of an Ivy League university, Columbia University. I hold a Doctor of Law degree from George Washington University Law School. I have 5 degrees, right? So I didn't need these psychiatrists that I was sent to by this judge, based on a wrongful commitment and fraud on the court. I didn't need them to be able to tell me that, well, I'm highly intelligent. But that was what they they surmised. That was their evaluation regarding, the assessment that, look, I was highly intelligent. So that box wasn't checked. The box of, well, mental retardation. The second reason why the judge can commit you to do a competency to stand trial evaluation is if you have a mental illness that's so severe it prevents you from understanding your charges, understanding courtroom proceedings, and being able to work with your lawyer. Again, the, even though I had told the judge I had not demonstrated anything outlandish, I had not done anything freakish, the judge never let me speak in court for about a year, over a year. He wouldn't let me speak. So they basically were committing fraud, right? Because the person who did the false emergency call, who did the hoax, hired a lawyer for me because I was held wrongfully in detention, right? No access to my family. So the person sent an attorney, paid an attorney to come and represent me. And that attorney now committed fraud on the court by making misrepresentations to the judge that I didn't know what was going on, that I was so ill, I didn't know what was going on. So that attorney was making misrepresentations to the judge. And that's actually misconduct. It's basis to be disbarred or to, some kind of suspension, punishment as an attorney, because it's actually it's misconduct, right? So he lied to the judge. So of course, and I couldn't say anything in court. I wouldn't say anything because the judge can find me in contempt. I went to law school. I didn't say anything, but the attorney would be telling lies, saying, well, this person doesn't know what's going on, blah, blah, blah. And I filed a attorney misconduct and malpractice against him with the Maryland bar, but it looks like they're a racket. So they all do these things together. It's just like an old white boy network, and they all do these corrupt practices together. I filed complaints against the judge, Judge James Bonifant, but they keep saying they're investigating, and so they have this sort of corrupt racket going on in Maryland with their bar association. The criminal justice system is unfair against Black people, Black men especially, uh, in part because the humans who are lawyers in Maryland, who are judges, who are law enforcement, are crooked, right? They're doing something, they're breaking the law, right? It's not that, the laws are there to protect them, to be equal, but it's not administered in an equal manner. And Black men are not inherently criminal. They're not crazy as the law tries to misrepresent them, because this was what was going on in Maryland. This judge was trying to misrepresent me, and there was a white lawyer that the crazy guy who did a false emergency call hired to represent me. And There was a white judge as well, and they were in on it together, pretending that gaslighting basically that okay that I'm insane or I'm mentally ill. I don't know what's going on. They first started with retardation, so eventually the hospital that they sent me to, apart from the fact that my aunt, who's a psychiatrist, had written the judge, petitioned the judge that no, I have no mental illness. And she talked to me for hours, examined me for hours. She couldn't find anything. My mother did the same. My friends, everybody I'd been interacting with had written this judge, petitioned that there's nothing wrong with me. But the state of Maryland uses the excuse, the pretext that because they have a charge against me, the judge can, he could order me around arbitrarily. So this was a court order. So they send me there anyway. I do go to the hospital, right? But fortunately, the psychiatrist in Maryland there, the psychiatrist they sent me to, all of them, they said no, they said the same thing. They came to the same conclusion that this man has no mental illness. We couldn't diagnose him with a mental illness. We couldn't give him medication for a mental illness because he doesn't have any mental illness. We don't see anything. Whoever said they saw any signs, they were wrong. They made a mistake, right? So they told the judge twice, in court, they appeared, said, no, this man has no mental illness. So in any event, when I was there, you still have a judge, a psychiatrist still has to sign off and say, you are competent. He has to, because it's a court order. The judge has ordered it. So you can sue them later on, right? That's your right to file a lawsuit against them if you've been wrongfully committed, like I was, right? But while you're there, because they're using this pretext that, well, you've been charged with a crime, there's nothing they can do. Only a judge can release you, right? So unless, and the psychiatrist is going to try and do their job. So the psychiatrist, does his job and says, no, there's nothing wrong with this person, but they have to give you a test. So one of the so I'm just going to go over the sort of things that they ask you, and that's courtroom proceedings, right? So basically, um, when you are, so a criminal case is brought against an individual, right? A suspect or a defendant by the state, right? So, assuming you're charged with assault, right? So, for instance, the police officer who assaulted me went to file a false statement, false charge, but under criminal proceedings, right? The judge accepts the charge statement as is, so that we've not reached the point where they evaluate. But the prosecutor should have looked at it properly because they have to look at evidence to know if they can carry the case forward or not. So that was prosecutorial misconduct, right? And the police also should be honest, but the police filed false charges because there's no evidence. So in any event, it gets to courts, right? And they file charges, and the prosecutor, the state attorney, that's the person who's filing charges against you. They're the ones who are trying to find you guilty in court, in the proceedings, right? So they're the one who file charges against you, who are bringing proceedings against you, who are trying to get evidence and show that you're guilty, to prove to a jury that you're guilty. So and they're representing the state. So the charges in a criminal case, you're defending yourself against, the defendant is defending themselves against the state. If it's a civil suit, for instance, it can be a party, can be two parties. Civil suit is not a criminal matter. You can't go to jail for a civil suit. So a civil suit, imagine, for instance, maybe you and your spouse, right? You sue one another, or your girlfriend sues you for some reason. You have a dispute over money, and one person is saying, well, you owe them this amount, and they sue you, so you go to court. So they're the plaintiff, you're the defendant, but it's a civil case because it's over money. It's nothing criminal. She hasn't said you stole her money or anything like that. So it's a civil matter. It's not criminal. And in a civil matter, what they're just going to do is um, uh, they can give you a penalty. What they can do is, because the plaintiff is the person who's bringing suit against the defendant, right? Who's looking for some kind of redress, remedy. So they could be asking for a recovery of their money, right? If they're suing for money, that somebody's owing them money, then that's what the courts will be able to do. So they have to prove their case that they did make a loan to this person and they're owing them such an amount, and the court can rule in their favor. So that's a civil matter. That's not what I want to talk about today. But in a criminal case, it's different. So, for instance, if two people fight, you and your neighbor, you get into a fight, right? And you beat your neighbor up really bad, and he has a black eye. That's assault. And somebody calls the cops. Somebody calls the cops. It doesn't even have to be your neighbor calling the cop, and the cop has to come and defend. The cop comes and separates you guys. Then the cop can arrest you at that time, or if they choose not to arrest, if there's an injury, they can send you to a hospital to get treatment. And the cop, based on the evidence they have, they can decide, and they'll go and talk to the victim. That's your neighbor that you beat up who has a black eye. They can go and talk to him and say, well, does he want to press charges against you? That means he's going to be uh, the witness for the state. So it's really the state that's going to bring the suit against you. And if they say yes, because the if they file a criminal suit against you, the state attorney, the prosecutor, that's the same person. The state attorney, prosecutor, they're representing the state in the lawsuit in a trial. They need to be able to present evidence in court, right, to find you guilty, to find the defendant, right? So at that, before you're charged, you're called a suspect, right? You're called a suspect, right? Because again, so our legal system is predicated on the the accused being innocent until proven guilty, and you can only be proven guilty in a court of law. That's the theory, that's academic, but we find that's often not the case. Um, so, because a reason why I said, even though you're supposed to be innocent until proven guilty in a court of law, you will find that sometimes the judge can order an arrest warrant for you to be detained even before your trial, right? So and the reason why the judge does that is if the state decides to file charges against you, right? If they feel they have enough evidence to convict you, then what's going to happen is the judge might think, well, you were just involved in an assault and they don't want you to go and keep committing more crimes, go and be assaulting people. They don't know why you assaulted someone. Um, it's a violent crime. So they can now order that, well, you should be detained, removed from the community, and they lock you up in jail because you might be a danger to the community. So for public safety, so the judge can order you to be locked up in jail prior to your trial, just for public safety, right? Prior to the trial, so because he doesn't want you, he wants the members of the community to be safe. So that's a reason why sometimes people are locked up. So you see, Puff Daddy, Diddy was locked up in for a long time before he had his trial, and even before he was convicted, because well, that was a violent offense. And even though Diddy had a lot of money, he could afford bail, but the judge thought, well, that because he'd been involved in something violent, they didn't want him to, even though maybe it's not maybe that's not reality, but that's just how judges think. The judge will think, and the state would ask for it, that okay, we want this person to be detained in jail because until his trial, right? We don't want him roaming around in the community freely like he's an innocent man. So it helps again the state to make the person look bad, right? Because the state is now going to be, it's an adversarial system, right? So the defendant is now in a conflict with the state. So the state wants to make the defendant look guilty, like a hardened criminal, and so they have the judge lock the person up prior to the trial. So that's one reason. Another reason is they may pose a flight risk. If the judge and the state feel that, well, because this person is facing this crime, this serious crime, and fears they might be convicted, they might flee, they might run away and not show up for their trial. So that's a reason why the state can decide to hold the person in jail for a while. Now, the reason I was held detained was because the judge and the state, they asked me to go and do an evaluation, because this started with a perjured emergency evaluation petition. So it wasn't a crime. It was just somebody, who went to go and lie. This man called G.D. Really, a Howard University professor who was impersonating himself as my uncle and then lied in an emergency petition that I had no idea existed, lying that I said I was going to shoot him, lied that I said my home's a military base, just told all sorts of lies, right? The man might have dementia, he might be dangerous, but the state hasn't done anything regarding him because I know, from what he also said, he claims he was pressured to do it, to file the fraudulent petition by the government, right? So I was working in the Department of Defense and I reported people for fraud. So what they were trying to do was obstruct justice. This man had come to me previously, asked me to withdraw my EU complaint and other complaints in the government, saying they knew important people and they could hurt me. So I don't know what they did to him. I don't know why he did it. And so the state has been protecting him, knowing that they orchestrated the whole thing. But let me get back to the EAP. So it was based on an emergency evaluation petition. That was what they were supposed to be coming for. Um, but things didn't go as they planned, or maybe it did go as they planned. So I refused to do an evaluation. Right after they'd shot me in the head, and maybe that was why they shot me in the head. I don't know. Maybe that was a sharpshooter. So they wanted to do an evaluation, and I refused. I said I'm not going to do an evaluation because one, uh, I have a family. My mom's in Nigeria. I want my mom to be present, and so they kept asking me to do an evaluation, and then even in jail, because they have psychiatrists in jail, so they would bring their psychiatrist to come and ask me. I'd say no, I'm not gonna. That's not gonna happen. Fortunately, they have a so he now got me an attorney, and so they released me, asking me to go and do an evaluation on my own, and I refused because that's my right, saying that no, because the emergency evaluation petition was fabricated, it was perjured, so I had a right inside. I said no. So the judge was using that to punish me and to try and compel me to do an evaluation. So he was using a trick, right? A circuitous way to get an evaluation done using the false emergency evaluation petition. Sorry, the false incompetency to stand trial orders that he was meting out, it was executing in court and to compel some kind of evaluation. So that was a violation of my constitutional rights, and through he was using fraud on the court. So I was just explaining why, in my case, I was detained because I was detained for about 15 months in jail. Apart from being held at home, I was prevented by the judge from going back to my home because my home was destroyed, but that was still my home. The release was in my name, but I had to now stay. I had to go somewhere else, and stay somewhere, rent from somewhere else, and that was an inconvenience. And I had to wear a GPS, be under house arrest for a year, for about a year. So, apart from the 15 months in which I was detained, so it's been 3 years now since, and I haven't had a trial. So, um, these are some of the reasons. Once you have a criminal charge against you, even if it's wrongful, even if it's proper, these are some of the inconvenient things that can happen. The judge practically said he wanted me to lose my federal government job and prevented me from going to work. I had a new job offer, a six-figure job offer at the Pentagon, as soon as I came out, because I just told them what had happened. And that's but the judge said he wanted me to lose that job, right? He wanted me to lose my job in the federal government. And so these are illegal. They're violations of 14th Amendment rights. I'll do a video on 14th Amendment later on. But in any event, so uh, the reasons that a judge can keep you detained before your trial is one, uh, if he considers you a danger to public safety, the community. The other thing is he thinks you pose a flight risk. So once that's done, and then you're doing your competency to stand trial, if he finds you competent, uh, I was always found competent. If they do an evaluation and they find you competent, they release you. I haven't had a trial yet. I'm still being held, so I'm at home, right? I'm not detained, but I'm at home. In fact, I'm at home still waiting for my trial. even though we till today we haven't seen the evidence of what it was that I did. The assault, the evidence that we have is of the police assaulting me in my home without an arrest warrant. So that's police misconduct and prosecutorial misconduct. But in any event, um, so back to the proceedings of trial. So the state attorney is the one who gathers evidence against you, and they gather a witness. One of the witnesses that they will gather, for instance, if it's an assault case, the scenario I gave about you being involved with in a fight with their neighbor. So I'll just say the defendant is X, and then the the victim is Y. That's the neighbor Y. Uh, Defendant X. So they're still suspects. They bring charges. So the state's going to tell the defendant X what his charges are, and then the the case is going to be titled as the state versus defendant X, right? So the state is the plaintiff, even though you didn't exactly get in a fight with the state, it was your neighbor Y, but the state for criminal cases, the state is always the plaintiff. So neighbor Y is just going to be can serve as a complainant of the victim for the state. So and amongst the things is, of course, they gather evidence, and then now for a criminal case, you're entitled to representation, right? That's an attorney. If you don't have money, you can use a public defender. The state will give you a public defender. So the public defender actually works for the state. They're paid for by the state. They're under the office of the attorney general within the state, for instance, in the state of Maryland. But um, they're paid to represent you because that's part of the Constitution. You have to have defense. So if you don't have money to hire an attorney for yourself, because attorneys are very expensive, then the state has to assign you a public defender who's your attorney. They're supposed to be fighting on your behalf to set you free, to say you're innocent, to show your part, to represent yourself and show your part. During the process, sometimes the state might offer you a plea bargain. In fact, in certain states, 98% of criminal cases, are settled out of court through a plea bargain, right? Because it costs money to go to trial, one, and the defendant is entitled to have a jury trial. It costs money, they're going to pay for the jury, and because they have a jury trial, there can be a mistrial. For a jury trial, the jury are the people, they're 12 in the state of Maryland, depends on the state, right? So they're normally 12 people, right? And all of them have to be unanimous. All of them have to be on the same page. They have to all vote one way. You can't have 11 people vote guilty and one person say not guilty. Then that's called a mistrial. There'll be a mistrial. They either try the case all over again, which will cost more money again, or sometimes the state attorney will choose not to bother anymore. But a mistrial is not an acquittal, but the state failed to prove their case. So the state standard of proof is the burden of proof is on the state. They're the ones who have to prove the guilt of the defendant and the standard is the highest for criminal cases. It's beyond a reasonable doubt, right? So it's not the defendant who has to prove that they're innocent. So all the defendant has to be doing is chipping away at the evidence. Now, also and what the state is going to use to convict, to have the defendant convicted of the crime is evidence, right? That evidence has to be presented in a trial, and the state has to also present all that evidence to the defendant, right, through discovery. So a good attorney has to conduct discovery, and they're going to ask the state attorney, the prosecutor, for all the evidence they have. For instance, we've asked for evidence, and there's been no evidence to date. It's been 3 years of me committing any crime against the police. In fact, the evidence shows that I've been the victim of police brutality and an illegal search and seizure in my home, right? So it's up to the state to get the evidence to convict, and they have in discovery, the the defendant's attorney asks for all the evidence, right? They have to have it ahead of time. And under the law, there's something called the Brady Rule, the Brady Doctrine. The Brady Doctrine requires the state to provide any exculpatory evidence to the defendant, right? So if the state attorney knows, if they have evidence proving the innocence, showing that, well, the defendant didn't commit the crime he's been charged with, showing that he's innocent, the prosecutor, even though it's an adversarial system, the prosecutor cannot hide that evidence. Under the Brady Doctrine, the prosecutor is required to show the defendant the evidence that he found that the defendant is innocent, right? So it's that's called exculpatory evidence. It exonerates the defendant that, well, they didn't commit a crime. Now the other side, the person that the prosecutor is prosecute his the prosecutor is prosecuting on behalf of the state in defense of the victim, right? So the victim, as I said, neighbor Y. Neighbor Y is the victim, is not the plaintiff. The state is the plaintiff in a criminal case. So under the Brady Doctrine, the the prosecutor has to provide exculpatory evidence. That's evidence that the defendant is innocent, which they come across. If they find any, because they're going to investigate, the state has the resources to do a thorough investigation, because the police works for the state, so they have their detectives. They go and do an investigation, and once if they find evidence that tends to exonerate the defendant or is mitigating, they're required to provide it to the defendant. The defendant's attorney doesn't have to ask for it. If the prosecutor just comes across it, they have to provide it to the defendant, right, to the defendant's attorney. So that's what's called the Brady Rule, the Brady Doctrine. It's prosecutorial misconduct if a prosecutor has evidence of the defendant being not guilty. They can get disbarred. They can suffer some kind of penalty, be suspended. They will be reprimanded, because it's actually attorney misconduct and prosecutorial misconduct. I'd done an earlier video regarding the Korematsu case, and much 40 years after their conviction, that's regarding the Japanese internment, it was found that the attorney, who was a solicitor general representing the United States at the time, the government, it was found that they had evidence from the FBI and the Navy that the Japanese were not a threat. There was no reason to imprison them, and that would have exonerated them. And that was another reason why. But they never provided that evidence to the attorneys representing the defendants. So the Japanese defendants, including Korematsu. So those cases were overruled because of that. So that's called the Brady Doctrine, right? So it's a violation. Now, something else is the judge. So the judge is the one who, I've been talking about a judge. The judge, we know from movies, the judge is the one who presides over the courtroom, is the decision maker in the courtroom. He sits on a dais. That's an raised platform. And he's the only one who's facing the rest of the court. Everybody's facing him, right? The criminal cases are open to the public, so they could be sitting in benches and pews in the back, but they all normally facing the judge. And the judge has a gavel. He maintains order in court. He normally has a bailiff. So a bailiff is like a sheriff or an officer who's there for security. Of course, and then you have the jury, the 12 in the jury, they're from the public. They pick them from the public. And that's why they say jury of your peers. They're random people, they're citizens. It's not their job. Anybody can be called for jury duty. And so the defense the defense attorney, that's your public defender or your private attorney, and the state attorney or prosecutor, they're going to interview the jury, right? Before and make the selection, if they want people on the jury or not. So they're going to eventually choose 12 people, and all 12 have to agree that, in order to find the person guilty or not guilty, right? So, and that's that. So, apart from and their plea bargains, the three types of plea bargains they can offer you is, um, they can offer you. Let me see, what are the plea bargains they can offer you? Mm, well, not plea bargain. So a plea bargain is an offer by the state. It's an offer by the state, uh, so you don't go to trial, right? They can make you an offer and they reduce your sentence or reduce. They can say that they won't prosecute. For instance, they gave me a plea bargain. They made me an offer that they dismissed the charges if I go and do an evaluation, blah blah blah, take treatment. I refused. I'm not going to use it's false. I the violation of my First Amendment and gaslighting. I was just sitting in my home when I was raided by the police, so there's nothing wrong with me. I didn't complain of anything. Why should the police come and assault me, and then the state files false charges against me, and then they want to coerce me? The prosecutor had said something that violated my constitutional rights. He said I was a victim of a police brutality, right? That I was a victim, but she only filed these charges as a to use it as a mechanism to force me to go and do an evaluation, right? So that's a violation of my constitutional rights. I said, no, that's not going to happen, right? So they can offer you a plea bargain. That's just a deal. Sometimes they can say, well, they'll dismiss the case. But basically, if you accept a plea bargain, you also have to accept guilt, right? So even if you don't serve time or anything, once you accept guilt, then you cannot sue the state. That's the other thing. You're saying you're guilty. If you want to file a lawsuit later on that they committed police brutality, you can't do that because you're guilty. You've said, well, you're guilty. So that's a reason not to take the plea bargain. By the way, if you don't take the plea bargain, you get to go to trial and you get to show your innocence. You get to say your side of the story and you get to show the world, if you're an innocent person like me, you get to show the world, the how you suffered police brutality and a miscarriage of justice, right? You get to be able to do that. You have your day in court. But in court, you have the pleas you can make. You can say it's guilty or not guilty. One thing that they do in Maryland is they give you an opportunity to say not guilty by reason of a mental illness, but you committed the crime. But in America, a criminal case, there's something that's required. Two things are required in order to convict, right? They need what's called actus reus. That's Latin. Actus reus is the act. For instance, if somebody's saying that you committed an assault, the actus reus is, well, you hit somebody, right? Boom. That's the actus reus, right? That's the action. Then the other thing you need is intent, right? The lay people, we call it intent. In Latin, it's called mens rea. That's guilty knowledge, right? You're guilty of a crime, that you had an intent to commit a crime. So, for instance, if there's a car coming, right, speeding at you, and you jump out of the way, and then you fall and you hit somebody, right? You hit somebody and they fall down, right? Are you guilty of a crime? Can they find you guilty? No. There's actus reus. They hit you because you were trying to evade uh, a car that was going to kill you, that was going to hit you, and so you fell. You jumped out of the way, and then you hit somebody, a pedestrian, and they fell down. But that was actus reus. But there's no mens rea because it was an accident, right? You didn't plan to hit the pedestrian, right? You didn't plan to harm them. So there's no mens rea. The same thing with so you see, so it's sort of like an insanity plea. So if you can't have, so the common law, English common law, considers that somebody who has a mental illness is not able to form, may not have the capacity, or if they're insane, they don't have the capacity to form criminal intent, mens rea. They don't have the capacity to do it. So typically, the state won't be able to, the jury won't be able to convict them because they don't have the requisite mens rea, right? And so many times, if they accept that, plea that, well, not guilty by reason of a mental illness. Yes, they committed a crime, but maybe they had a mental illness that prevented them. For instance, there's somebody who may have bipolar disorder, and some people have impulsivity because of that bipolar disorder. And so if they couldn't control themselves because of the bipolar disorder, they didn't use their medication, and they hit someone accidentally, they hit someone, they did it, but part of bipolar disorder is, they get really emotional and angry. It's impulsive and they can't control it. And they did it, they hit the person, they can take that sort of plea that, well, they did commit the crime, they did hit someone, but they didn't have mens rea, right? They did it because of the mental illness they have, right? So that's not guilty by reason of a mental illness. So that's like a temporary, that's like insanity plea. That's Maryland's equivalent of an insanity plea. So different states have their rules, right? Each state has their rules, their criminal law procedures, right? So once a judge approves that, though, then the person doesn't get to go scot-free. They send them to a psychiatric hospital to take treatment, right? Until a psychiatrist says they're well. So if, for instance, if they were to, if they had, and people think they can get away with, while I was wrongfully detained, I saw a lot of people, this was what they were trying to get away with. So a lot of people who think they committed a crime, they're guilty, they pretend like they're ill, like they're mentally ill. So they'll send them to a hospital, a psychiatric hospital. They'll take treatment. The downside of that is that if a judge approves it, so they don't go to prison, so they won't go to prison. So instead of being convicted of a crime that's maybe 1 year, right? At least if they're found guilty, if they go to trial or if they plead guilty to the crime, maybe it's some kind of battery crime that the sentencing is 1 year, right? Or trespassing or something, and the sentence is 1 year or 8 months. At least if they're guilty, they know how long they'll spend in prison, right? They know how long they'll spend in detention once they're sentenced, right? They're convicted, they're found guilty. They know how long they're going to do. 1 year, right? They're guilty, boom, 1 year, they're done. Or 2 years, they're done. 3 years, they know when the judge sentences them, okay, go to prison, you're guilty, they know exactly how much time they're going to do. The downside about taking the third option, right? Again, the three pleas are guilty, not guilty. So when the judge is going to ask, once the charges are read in court, they're going to ask the defendant, how do you plead, guilty or not guilty? But if a plea bargain is offered, so there's a third, and the third is, yes, they committed the crime, but they're not guilty by reason of a mental illness, right? They're not responsible. That's it. Not criminally responsible. That's what it's called in Maryland. NCR, not criminally responsible. They're guilty of the crime, but not criminally responsible by reason of a mental illness. So the judge, if he approves it, he's going to say, instead of sending them to prison to do time, he's going to send them to a psychiatric hospital, right? And in the hospital, the thing is, there's no time limit. They don't say, well, you're going to just stay there and take treatment for 1 year or 2 years. I saw someone, a Nigerian, and that was the sad thing. He was a student. And I'm not going to say why, but he was a normal guy. He was in college. He comes from a good family. His father's an attorney, and I could tell. But he'd been in this hospital. There's a much harsher psychiatric hospital that they send people who've been convicted, right? Very, very, like the people who are like really criminals, really severe illness, they're dangerous people. But if you're sent to go and do an evaluation like me, then there's a mild place, right? That just maybe mild behavioral people, that people can just check themselves in and they're not serious. And the court sends people to go and do an evaluation, right, for a trial because they have a pending trial. So like this guy, he was on his way out. He had done 8 years because he had accepted a plea bargain. He had accepted a plea saying he was guilty for something. And he was a kid then. He was in college. He came from a well-to-do home, and his parents sent him to school. And so he accepted and they charged him with a crime. Actually, it was for drugs, right? It was weed. It was when weed was illegal. Nobody knows who the person is. I'm not saying who the person is, and his case is virtually over. So back then, weed was, it was illegal, and so he was an F1 student. He didn't want to be deported. He didn't want his parents to know. So they charged him, and then his defender tricked him. That's how he put it, because he was a kid. He was just 18 years old, and so he's just about 19, just over 18 at the time. So his defender told him, "Well, look," he said how the prosecutor was threatening him that, look, they're going to convict him, right, for this. It was weed. They're going to convict him, and after they're going to deport him back to Nigeria. That would be the end of his schooling. So the guy thought, well, he knew he was not. So his public defender persuaded him to take the not NCR, not criminally responsible by reason of a mental illness. The guy told me he knew he didn't have a mental illness, right? So he thought, well, he's just going to go to the hospital and maybe they'd release him after 5 days or a week or a month or whatever, that once the doctors see him, evaluate him, and see that, well, that he's fine, they'll let him go and it'll be done. And it won't be on his, he'll be done with it. He'll avoid prison. However, he thought would be less than a month ended up being 8 years. So this boy was, he's in his 20s now, going on 30, and you can see the effect of the drugs on him. And he's still hopeful. And he found out that I had a law degree, and he was talking to me because I used it as my opportunity to do an investigation of the conditions. Why do people get into these hospitals? What's going on? Is the system working or not? So I saw the lapses in the system. I saw the criminality of the judges, like Judge James Bonifant, the corruption of the state attorney, the corruption of some psychiatrists, some doctors, state psychologists, like a Dr. Julie Smith. I saw, the collusion, right, and violating people's rights. And of course, there's money involved. When they put you in those hospitals, even though they're state of hospitals, and it's a state that's asking you to go. Can you imagine? I was given a bill. I was asked to pay $30,000 for 1 month. So each time I was there, they were asking for my bill. I refused to give them my social security. So I told them, I'm not giving you my consent, right? This is a wrongful involuntary commitment. I'm still gonna, my family's gonna file a lawsuit against you. So we've not given consent, right? This is fraud. So I saw later on that it looked that they were committing fraud. They used somebody else's social security, because there were many of the people there as well. They were sent there wrongfully to go and do evaluations. So many refused to give their social security, saying no, that that they're not giving their consent. That's the judge who ordered them on pretext that they have a court case, a criminal case against them. And the hospitals, some of the staff, they go and look for, especially their social workers, they go and forge somebody's else's social security so that the state can pay them. So they're committing they have a racket in the state of Maryland in which they're committing fraud. And Judge James Bonifant is part of that racket and the healthcare systems there. So, but that aside, so this kid, though, this boy, unfortunately for him, what he thought would be 1 month, the doctors didn't find him, found a mental illness and something to treat him for. And that's a requirement also. You can't just be there and refuse treatment. Like me, it was for an evaluation. I wasn't given any treatment, any medication. I had a right to refuse. And fortunately, the doctors thought the same thing, that there was nothing wrong with me. But I had a right to refuse. The state of Maryland gives you a right to refuse. But once you take that NCR plea, right, if you take that plea bargain, that not guilty, not criminally responsible, to avoid prison, then to end the case, to avoid prison, then the defendants cannot, they cannot refuse treatment. If they refuse, they can strap them up and they can force medicate them. A judge would order forced medication. You can strap them up and they'd be injecting them. So that's one of the dangers of accepting that plea bargain of not criminally responsible, right? So those are the three plea bargains. Now, the video's gotten long, but I think I've covered pretty much a lot of what I wanted to talk about. And you know, their their rights that the person says has. And I will end this video here. It's already getting to an hour, and so what I'm going to do is uh, just a little, just a few more topics I wanted to focus on regarding legal proceedings. My name is Olurotimi Osha. I'll keep you posted. Thank you.